Hi, I'm Hannah Edwards. I'm an associate at Osborne Clarke, and this is Leanne Gulliver, a senior associate and trademark specialist. We're going to be talking about a few things that we think is important for trademark owners to know following the Court of Appeal decision in the case of ICE versus ICE. So Leanne, perhaps you could start off just telling us a bit about what happened in this case and why it's important for brand owners to be aware of.
So this case involved a dispute between two companies who had been coexisting in the UK for 5 years, both using ICE trademarks. The claimant brought invalidity, infringement and passing of claims against the defendants, and the defendants sought to rely on the defence of statutory acquiescence. Now, the case arose because both parties had been coexisting. So one of the key takeaway points for brand owners is if you become aware of a third party using an identical or a confusingly similar trademark, then you need to act swiftly to take action.
Okay, so the key point is if you're aware of a conflicting mark, whether it's a trademark or a logo that's similar to one that you're using, you just start thinking about bringing enforcement proceedings as soon as possible. And how was the Court of Appeal's approach in this case different to what had happened previously?
So up until this decision, the earlier trademark owner had to have knowledge of the later trademark registration and use of that mark to rely on the defence or acquiescence. However, in this case, the Court of Appeal held that the earlier trademark owner didn't require knowledge of the registration, so knowledge of use was sufficient.
Okay, and how does this decision in the UK differ from the EU position?
So this was the first IP case where the Court of Appeal departed from the EU case law post-Brexit, and the Withdrawal Act contains powers that allow the Court of Appeal and the Supreme Court to depart from the assimilated EU case law where it feels it's right to do so. And these are also the same powers that the Supreme Court can rely on to depart from its own case law. So the hurdle for doing so is obviously high. In this particular case, there were several reasons why the Court of Appeal looked to depart from EU case law, and the Court of Appeal didn't rely on those powers lightly. And for example, one of the reasons for doing so was because the EU IPO and the General Court case law differed.
So it sounds like brand owners might need to take a slightly different approach in the UK compared to what they do in the EU. So what is it that they need to do differently in the UK?
So this decision definitely puts the responsibility on trademark owners to monitor the marketplace and to be looking out for third parties who are using identical or similar signs and taking enforcement action where appropriate. So by using cease and desist letters, for example. I think this case also highlights that brand owners should be actively monitoring the UK IPO register, so looking for identical and confusingly similar third-party trademark applications. So for example, we can set up a trademark watching service where the software alerts us to these third-party applications at an early stage, and then we can work with clients to advise whether a trademark opposition might be appropriate.
That sounds like a really helpful tool, thank you. And do you think we'll see the UK courts departing a lot from EU law in the future?
So the EU Retained Act does allow provisions for us to do so, but currently the section isn't actually in force. It was due to enter into force in October, but the current government has put that on hold for the moment. So I think for now it's a case of waiting to see what's going to happen in the future, but to definitely have it on our radar.
That's really helpful. Thank you, Leanne.
Thank you.